rocks. A family is taking Charlotte-Mecklenburg schools to court over a spirit rock. A newly filed lawsuit stems from a September incident at Ardrey Kell High School following the death of Charlie Kirk.
The family claims their daughter and her friends were given permission to paint the school spirit rock in Kirk's honor, but the school leaders have refuted that claim. The district instead said that the painting of the rock was vandalism. The girls' parents are now suing, saying that their daughter's rights were violated.
We want to bring back in our chief legal analyst, Khalif. Khalif, break this down for us in terms of what this lawsuit is talking about, because it also goes to the first part before we talk about amendment rights, whether or not the school gave permission or they didn't give permission, right?
Yeah, I mean, that would be, so you have a number of things that you talk about in this scenario. First of all would be, is it a First Amendment right violation? And before you get to that First Amendment argument, it's the administrative argument. Have you exhausted all administrative remedies? And so the first part that the court would ask was, is there a policy in place regarding rock, designs or utilization? I know as a parent that actually just did this last week for my daughter's birthday, there is a policy in place. You do have to get school permission. They give them permission. It's for one day. It comes right back down. So I know that's a process that CMS has. It's typically for birthdays or events. Historically in the past, it has been for other things that are happening with social issues as well. But there is a communicate with the school, receive permission, and then go. So we recognize and know that there is a policy in place. Now, what does that policy say? What are the rules, the requirements, and the stipulations, and what can be on the rock? That may be another question for another day, because it seems like there was a policy, and there may have been an amendment to this policy in real time while this rock scenario was happening. But then the other question is the First Amendment, and I said a number of times here, the government cannot chill your speech just because they want to. First of all, there has to be government action, and this would be considered government action. And then it's the chilling of the speech. It has to be a compelling public interest, and it needs to be narrowly tailored. That's strict scrutiny. I think that's how this court would review this. And so when you're saying, well, would they walk through that analysis first? I'm not sure if we get there. If they didn't have authority, then that question's blown out of the water anyway. But if we do get there, I think this one is going to be a very, very detailed walkthrough what a First Amendment case is. Specifically, are you attempting to chill her speech, and is it based on content, or is it based on you wanting to just stop her from speaking? If it's content specific and not content neutral, which it does seem like it's here, it's content specific, then they would have a claim. If it's content neutral, that I'm just barring all speech, not specifically what you said, then there is no claim. But based on these facts, it does seem like they're saying take down what you wrote because what you wrote, which would be content specific.
As a defense attorney, here's a would you rather scenario. Would you rather defend the school district in this case or the family?
Jason, that is an amazing question, and I love the way that you phrase it. And I can say this why, because I had this in my mind to try to figure out how to say it, and you just opened up the door, so I'll walk right through it. What I love about our Constitution is that it protects speech, even speech I don't agree with. And so in this scenario, why I don't agree with the comments of Charlie Kirk, I would love to defend the family in this scenario because I do agree with the First Amendment protections that are provided. So even this individual that I would not want to have agreed with in the speeches, I would totally agree with the family's protection of, hey, if you gave me permission, I can put whatever I want on this rock. And the fact that you disagree with it, furthermore, makes me love and support our Constitution. Because you have a right to disagree, and I have a right to disagree, makes us the best country. So yes, I'd love to defend the family because it's defending and protecting something I think is our most precious right, which is our First Amendment.
Well, so the family's suing the district. What do they get out of it if they win this? Is it monetary? Is it just more of a making an example?
Well, if I'm defending them, we're going to get some money. Let's go start with there first. but all jokes aside, I mean, any type of request like this, if you are seeking monetary damages, you're going to have to be able to point to damages first. And so that would be the first aspect of it. But then it's some type of an apology. It's some type of amendment to the process. It's going to be deeper than just the money, that this is a learning lesson for the whole administration and how you handle scenarios like this. First of all, you can't fix it while it's being broken. Let's deal with the scenario, and then after, adjust and apply new rules going forward. You can't apply rules while we're in the middle of doing this. So that would be my major issue with this. Back to Jason's question, that's why I would love to be involved, just because in that scenario, I think there are about 4 or 5 points that the family has to mourn that the school will have to have answers for.
All right, again, our chief legal analyst, Khalif, breaking that down for us, a case that we'll certainly be watching here. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.